Michigan Earnest Money Rules. Question 1. During a seller consultation in Traverse City, an employing broker encounters a rule involving an additional Michigan place of business maintained by a broker. Which response follows Michigan law, while the file concerns a 2-unit rental, a branch-office inspection report, and a record inspection request? Option A. The salesperson obtains a separate broker license. Option B. Only an MLS subscription is required. Option C. The location is automatically covered forever. Option D. A branch office license is required. The correct answer is option D. A branch office license is required. Each additional brokerage location must be connected to an authorized branch office. For exam purposes, focus on the regulated relationship rather than an informal business custom. A membership account or salesperson credential does not license the location. Question 2. A buyer representative is preparing for a listing presentation in Muskegon. Which statement correctly addresses a branch office located more than 25 miles from the nearest boundary of the main office municipality, while the file concerns a historic residence, a buyer representation agreement, and a branch-office distance issue? Option A. The branch must close permanently. Option B. A customer may supervise the branch. Option C. An associate broker must provide direct supervision at the branch. Option D. No supervision is required. The correct answer is option C. An associate broker must provide direct supervision at the branch. Distance from the main office municipality triggers an enhanced branch supervision requirement. The transaction context changes the facts, but it does not change the underlying licensing duty. Remote availability alone does not satisfy the stated arrangement. Question 3. Which Michigan requirement should control when a listing licensee deals with the physical location requirement for an individual broker, broker company, or branch office during a buyer consultation, while the file concerns a student rental, a commission disbursement form, and a financing contingency? Option A. Use the address of any salesperson. Option B. Operate without a listed location. Option C. Maintain a physical address in Michigan. Option D. Use only a post-office box anywhere. The correct answer is option C. Maintain a physical address in Michigan. Brokerage offices must have an identifiable Michigan business location. A written office procedure should produce the same result in comparable transactions. An unrelated person's address cannot stand in for the licensed office. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee a pass in payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 4. At an offer review, the brokerage discusses a licensee selling property in which the licensee has an ownership interest. Which conclusion is most accurate? While the file concerns a vacant commercial parcel, a draft purchase agreement, and an unrepresented consumer? Option A. A disclose only after closing. Option B. A disclose the ownership interest and licensure in writing before an offer is signed. Option C. Tell only the lender orally. Option D. A conceal the interest if the price is fair. The correct answer is option B. Disclose the ownership interest and licensure in writing before an offer is signed. A buyer must receive advance written notice when the seller is also a real estate licensee with an interest in the property. In the described setting, the brokerage should document the step and apply it before moving forward. Fair pricing does not excuse non-disclosure. Question 5. A compliance question in Battle Creek concerns the purpose of a seller property condition disclosure. Which action or statement is appropriate, while the file concerns an industrial site, a branch-office inspection report, and a confidential price limit? Option A. Replace the buyer's inspection. Option B. A transfer title to the buyer. Option C. Guarantee the property will never need repairs. Option D. Provide the buyer with required information about known property conditions. The correct answer is option D. Provide the buyer with required information about known property conditions. A statutory condition statement communicates the seller's knowledge about covered aspects of the property. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. The document neither substitutes for due diligence nor conveys ownership. Question 6. How should a Michigan team member handle a situation involving a known material defect that affects a purchaser's decision, while the file concerns a new construction home, a buyer representation agreement, and a change of employing broker? Option A. Describe it as confidential pricing data. Option B. Hide it until after possession. Option C, communicate the material information as required rather than conceal it. Option D, remove it from every transaction file. The correct answer is option C, communicate the material information as required rather than conceal it. Material property information can affect value, safety, or a reasonable buyer's decision. For exam purposes, focus on the regulated relationship rather than an informal business custom. Deleting the fact from a file does not remove the underlying duty. Question 7. Which choice best applies the state rule concerning a seller disclosure form compared with a professional inspection to a license application, while the file concerns a mixed-use building, a commission disbursement form, and an owner-licensee conflict? Option A. The disclosure does not replace an independent inspection. Option B. The form guarantees structural soundness. Option C. The form makes all contingencies void. Option D. The form is an appraisal. The correct answer is option A. The disclosure does not replace an independent inspection. The seller statement reports knowledge rather than providing a complete technical evaluation. The transaction context changes the facts, but it does not change the underlying licensing duty. Appraisal and contingency rights serve different purposes. Question 8. A file from Kalamazoo raises an issue about refusing housing-related service because of a protected characteristic. Which answer identifies the governing requirement, while the file concerns a cooperative unit, a draft purchase agreement, and an expired license issue? Option A, permitted client screening. Option B, unlawful discrimination. Option C, a required agency disclosure. Option D, a lawful appraisal adjustment. The correct answer is option B, unlawful discrimination. Housing opportunities must not be restricted on a prohibited discriminatory basis. A written office procedure should produce the same result in comparable transactions. Agency paperwork or valuation methods do not justify unequal treatment. Are you looking for real estate actual questions? Visit our website pokerexams.com to access real estate study guide with actual questions and answers. Scan the QR code or click the link in the description to get real estate answer key today. Question 9. Before completing a property management meeting, which rule should the salesperson apply to directing buyers toward or away from neighborhoods based on protected characteristics, while the file concerns a farm parcel, a branch-office inspection report, and a property-management payment? Option A, a title search. Option B, a lawful zoning variance. Option C, a neutral market analysis. Option D, steering and discriminatory practice. The correct answer is option D, steering and discriminatory practice. Neighborhood recommendations cannot be based on the protected composition of residents. In the described setting, the brokerage should document the step and apply it before moving forward. Title and zoning work do not authorize discriminatory channeling. Question 10. A Michigan exam candidate reviews a scenario involving advertising that indicates a preference or limitation based on a protected status. Which option reflects the current licensing framework, while the file concerns a lakefront cottage, a buyer representation agreement, and a delayed possession term? Option A, a lawful deed restriction. Option B, a required broker identifier. Option C, permitted puffery. Option D, a discriminatory advertising. The correct answer is option D, discriminatory advertising. Marketing language may not signal that protected people are unwelcome or preferred. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Broker identification and ordinary promotional opinion are separate issues. Question 11. The broker's policy manual addresses reasonable accommodation for a person with a disability. Which provision should it contain, while the file concerns a townhouse, a commission disbursement form, and a cooperating brokerage? Option A, require the person to waive civil rights. Option B, consider a necessary change to rules or practices unless an applicable defense exists. Option C, reject every request automatically. Option D, treat the request as a commission dispute. The correct answer is option B, consider a necessary change to rules or practices unless an applicable defense exists. Disability protections may require flexibility in policies so a person can use and enjoy housing. For exam purposes, focus on the regulated relationship rather than an informal business custom. A brokerage-fee issue does not resolve an accommodation request. Question 12. A regulator asks about keeping a client's confidential negotiating information private during a brokerage review. Which response demonstrates compliance, while the file concerns a urban infill property, a draft purchase agreement, and a rejected counteroffer? Option A. A fiduciary responsibility subject to legal disclosure exceptions. Option B. A reason to hide known hazards. Option C. A duty owed only to competitors. Option D. An optional courtesy after closing. The correct answer is option A. A fiduciary responsibility subject to legal disclosure exceptions. Agency loyalty includes protecting confidential information obtained through representation. The transaction context changes the facts, but it does not change the underlying licensing duty. It cannot be used to conceal material facts that must be communicated. Question 13. Which statement would be safest for a listing licensee to follow when presenting offers and material transaction information promptly becomes relevant, while the file concerns a subdivision lot, a branch-office inspection report, and an assumed business name? Option A. A task reserved for the assessor. Option B. A prohibited communication. Option C. Part of competent and loyal client service. Option D. Optional when commission is small. The correct answer is option C. Part of competent and loyal client service. Clients need timely information to make informed decisions about offers and risks. A written office procedure should produce the same result in comparable transactions. The size of compensation does not reduce professional responsibility. Question 14. A dispute arises during a compliance interview over an owner selling the owner's property in an occasional transaction. Which principal resolves the issue, while the file concerns a rural acreage, a buyer representation agreement, and a security-deposit question? Option A. An owner exemption may apply if the activity is not a principal vocation requiring broker licensure. Option B. Every owner must obtain a salesperson license. Option C. Only a lender may sell the property. Option D. The owner becomes a broker automatically. The correct answer is option A. An owner exemption may apply if the activity is not a principal vocation requiring broker licensure. Owners may generally handle their own property, but Michigan limits commercialized patterns of owner sales. In the described setting, the brokerage should document the step and apply it before moving forward. Ownership alone is not an unlimited exemption from broker licensing. Question 15. In Flint, a new applicant must decide how to proceed with an owner completing more than 5 property sales in 12 months without using a broker. Which decision is consistent with Michigan requirements, while the file concerns a single-family residence, a commission disbursement form, and a dual-representation concern? Option A. The owner remains exempt without limit. Option B. The transactions become tax-free. Option C. Only a building permit is required. Option D. The activity is treated as a principal vocation requiring broker licensure. The correct answer is option D. The activity is treated as a principal vocation requiring broker licensure. Michigan uses transaction frequency as one indicator of professional real estate sales activity. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Tax and construction approvals do not replace occupational licensing. Question 16. Which exam answer accurately classifies the rule involving an owner spending more than 15 hours per week over a 6-month period selling owned real estate, while the file concerns a small apartment building, a draft purchase agreement, and a protected class inquiry? Option A. The time is counted only after closing. Option B. The rule applies only to renters. Option C. The owner is always exempt. Option D. The activity can be treated as a principal vocation. The correct answer is option D. The activity can be treated as a principal vocation. Substantial weekly work devoted to owner sales can move the activity beyond casual disposition. For exam purposes, focus on the regulated relationship rather than an informal business custom. Closing dates and tenant status do not control this test. Question 17. A new policy is being drafted for the additional pre-licensure education associated with an individual broker applicant. Which language belongs in the policy, while the file concerns a office condominium, a branch-office inspection report, and a disputed repair credit? Option A. 90 hours beyond salesperson education. Option B. 10 hours of advertising only. Option C. No additional education. Option D. 40 hours total including salesperson education. The correct answer is option A. 90 hours beyond salesperson education. Broker-level preparation requires substantial coursework beyond the salesperson foundation. The transaction context changes the facts, but it does not change the underlying licensing duty. The additional requirement is not satisfied by repeating only the initial salesperson total. Question 18. During team training, the supervising broker tests knowledge of a salesperson license application under the statutory employer structure. Which answer should the team select, while the file concerns a condominium unit, a buyer representation agreement, and an electronic signature? Option A. The county clerk becomes the employer. Option B. The employing broker signs or approves the affiliation required for issuance. Option C. The applicant self-employs immediately. Option D. A home inspector signs as sponsor. The correct answer is option B. The employing broker signs or approves the affiliation required for issuance. The salesperson credential is issued within an employing-broker relationship. A written office procedure should produce the same result in comparable transactions. Independent practice is not created merely by passing the examination. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 19. A consumer asks the brokerage to explain a salesperson license as to legal form. Which explanation reflects Michigan law, while the file concerns a retail suite, a commission disbursement form, and a referral arrangement? Option A. It is issued to a branch office. Option B. It is issued only to an individual. Option C. It belongs to the property being sold. Option D. It may be issued to any corporation. The correct answer is option B. It is issued only to an individual. Michigan treats the salesperson credential as an individual occupational license. In the described setting, the brokerage should document the step and apply it before moving forward. A location or parcel cannot hold a salesperson credential. Question 20. Which compliance step is required when the transaction facts involve an associate broker's status, while the file concerns a manufactured home site, a draft purchase agreement, and a team social media post? Option A. A broker qualified individual working for another real estate broker. Option B. A county recording officer. Option C. An unlicensed assistant. Option D. A salesperson with no broker qualifications. The correct answer is option A. A broker qualified individual working for another real estate broker. An associate broker has met broker licensing standards but practices through an employing broker. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. It is distinct from clerical assistance and ordinary salesperson status. Question 21. A employing broker notices a potential problem involving a right-to list agreement that binds future owners for an excessive period. Which response should occur first, while the file concerns a 2-unit rental, a branch-office inspection report, and a record inspection request? Option A. Automatically superior to every mortgage. Option B. A substitute for a deed. Option C. Potentially unenforceable under Michigan restrictions. Option D. Required in all residential sales. The correct answer is option C. Potentially unenforceable under Michigan restrictions. Michigan limits certain long-term agreements that encumber future home-sale listing rights. For exam purposes, focus on the regulated relationship rather than an informal business custom. The arrangement is not a deed or a universal listing requirement. Question 22. The state portion of the exam presents facts about the body created to regulate Michigan real estate brokers and salespersons. Which result is supported, while the file concerns a historic residence, a buyer representation agreement, and a branch-office distance issue? Option A. The County Planning Commission. Option B. The Federal Reserve Board. Option C. The Michigan Board of Real Estate Brokers and Salespersons. Option D. The Local Register of Deeds. The correct answer is option C. The Michigan Board of Real Estate Brokers and Salespersons. Article 25 establishes a state board for the licensed brokerage professions. The transaction context changes the facts, but it does not change the underlying licensing duty. Local land offices and federal banking regulators perform different functions. Question 23. Which brokerage practice properly addresses the department's role in professional licensing in the Kalamazoo transaction, while the file concerns a student rental, a commission disbursement form, and a financing contingency? Option A. Record deeds for each county. Option B. To determine eligibility, issue credentials, and enforce the occupational code. Option C. Approve all private purchase offers. Option D. Set every property's market price. The correct answer is option B. Determine eligibility, issue credentials, and enforce the occupational code. The licensing department administers applications, examinations, renewals, and compliance. A written office procedure should produce the same result in comparable transactions. County recording and market valuation are handled through other processes. Question 24. A licensee is comparing 4 procedures related to a listing agreement that discriminates on a prohibited basis. Which procedure is lawful, while the file concerns a vacant commercial parcel, a draft purchase agreement, and an unrepresented consumer? Option A. The discriminatory provision or conduct is unlawful. Option B. The clause controls if the seller requests it. Option C. The broker must follow it without question. Option D. The clause becomes valid after advertising. The correct answer is option A. The discriminatory provision or conduct is unlawful. A client instruction cannot require a licensee to violate housing civil rights law. In the described setting, the brokerage should document the step and apply it before moving forward. Private preference does not override public legal protections. Question 25. At the end of an advertising campaign, the parties question mixing client transaction money with brokerage operating funds. Which statement provides the best guidance, while the file concerns an industrial site, a branch-office inspection report, and a confidential price limit? Option A. A required interest allocation. Option B. A standard marketing practice. Option C. Commingling that can lead to discipline. Option D. A permissible commission advance. The correct answer is option C. Commingling that can lead to discipline. Money belonging to others must be accounted for separately from the firm's own operating cash. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. A business convenience does not justify blending the accounts.